Over the next year, changes to Ed Law 2D will take effect. These changes have drastic implications into how schools work and share data. Over the course of this video, we'll delve into the changes, how they impact the district, teachers, students, and parents. This is only a brief overview of the major components of the law. If you have questions regarding how these changes will impact you, please contact the IT department and we'll do our best to answer those for you. Ed Law 2D addresses issues with data protection. Schools and organizations that do businesses with them will need to take steps to ensure that personal identifiable information, PII, is secured. So what exactly do we mean when we talk about personal identifiable information? We mean information that can be used to distinguish or trace an individual's identity, either alone or when combined with other personal or identifying information that is linked or linkable to a specific individual. So in layman's terms, examples of PII include Social Security numbers, driver's license numbers, bank accounts, passport information, biometric information, school identification numbers, private personal phone numbers, and credit card numbers. These are just a few examples of PII. Many more exist. Examples of non-PII include birth date, place of birth, religion, ethnicity, and sexual orientation. If you look at these examples, you can tell that these pieces of information alone can be linked to multiple people and therefore are not personally identifiable. The requirements of Ed Law 2D can be broken down into two main groups: data protection and transparency. When we look at data protection, we include things like protection of PII, data security and privacy policies, annual employee training, third-party contract compliancy, NIST cybersecurity framework, parent complaint procedures, and data protection officers. With transparency, it includes the Parent's Bill of Rights, incident reporting and notification, and again the data protection officers. We will look at this in greater detail in the next few minutes. Educational agencies have specific responsibilities and rules that will now have to be followed. For instance, districts are prohibited from selling, using, disclosing, allowing any other entity to use or disclose PII for marketing or commercial purposes. They must include provisions in contracts with third-party vendors that require confidentiality of PII. They must have a Parent's Bill of Rights for data privacy and security. It must be posted to the district website and must be included with every third-party contract where data is shared. The district must include supplemental information for each contract, such as exclusive purpose for data use and how the contract will comply with requirements for security. This document must also be posted to the district website. Districts must establish procedures for parents and eligible students to file complaints about breaches or unauthorized release of student data. They must adopt the National Institute for Standards and Technology framework for improving critical infrastructure cybersecurity version 1.1, the NIST framework, as a standard for data security and privacy. In layman's terms, it's a really tough thing to do. Districts must adopt and publish on the district website a data security and privacy policy that complies with the proposed regulations, aligns with the NIST framework, and includes provisions that require every use of PII to benefit students and the district, and prohibits PII in public records and other documents. The data and security policy and privacy policy must be provided to all third parties receiving PII. But wait, there's more. Educational institutions must provide annual information privacy and security awareness training to all officers and employees with access to PII. They must designate an official data protection officer. All third-party vendors are required to notify the district of any breaches or unauthorized release of PII. Failure to do so can result in fines. In turn, the district must notify the state chief privacy officer, and that person is required to report to law enforcement any breach or unauthorized release that constitutes criminal conduct. The district must review access to PII and ensure that it is accessible only to those that need it for the duties of their job and only to that specific data. Finally, data must be protected. That means encryption and secure passwords, among other security measures. So what does that mean to us? The district will provide professional development every year. Documents will be published on the website. Processes will be in place for addressing breaches, purchases of any product that include access to PII, Specific security standards will be followed, the NIST framework, and specific rules will be in place for the use, storage, and transmission of PII. In addition, each product's service level agreement must be carefully read to ensure compliance, and that if it's not in compliance, we will have to work with the vendor to ensure it is before purchasing it. Now, what does this mean to you? Any application or software that uses PII must follow the guidelines set forth in Ed Law 2D. Information that is being transferred must be encrypted. The use of cloud services for sharing, storing, transferring of PII is not allowed unless it has been approved for that specific purpose. Encryption of laptops is required. An email must not contain any PII. As you can see, there are a lot of changes coming in the near future. Some companies are moving forward with specific rules regarding the use of personal information. The CNY RIC is working closely with us to provide additional services that will help streamline the process. Now, this is a very difficult and confusing set of rules that will impact the way we educate our students. If you have questions or just want to learn more, please don't hesitate to get in touch with the IT department. We will work with you, vendors, and the RIC to help make this process as seamless as possible.